When your criminal case didn't go the way that you wanted and it ends in a conviction, you have a right to an appeal. What's that all about and what's the process? Stay tuned to find out. This is attorney Andy Marcantel and attorney Marc J. Victor. We're the partners at the Attorneys for Freedom Law Firm here with our final episode. It's our final episode, Marc. It's kind of bittersweet in our Fighting the State series. How you doing, Marc?
I'm awesome as usual, and it is kind of sad to come to the end of this series, but we will find other reasons to fight the state. I mean, that's what we do, so we will kick off other fights with the state, but we need to terminate this one because really we started right from the beginning, and this is the point. You hope you never get here, right? This is the part that, if you did go to trial, you need to win it, right? You want to win it, but you don't always win it. And, sometimes we get these from people. In fact, a lot of times we get these from people who had other lawyers and they wanted to change lawyers for their appeal. And so we get these cases and we're looking at them with fresh eyes. And so oftentimes it is a different attorney who does the appeal, but sometimes not. And so things don't always go as you planned. And if they don't go the way you wanted, now you're talking about an appeal.
Yeah, I've talked to so many clients who have come from other attorneys, maybe even the public defender's office, who after their conviction and trial, they feel hopeless. They feel like they're facing a ton of time. Maybe even their sentencing is coming up, so they haven't even been sentenced yet. Or maybe they just got past sentencing and the sentencing went horribly wrong, right? Because a lot of time with a lot of different crimes, the judge has a lot of discretion. Could give a probation sentence, could give a fine, or could send you to prison, depending on the severity of the crime. So whenever I talk to people who are in this situation, it all starts with education. I have to start with the basics. What's an appeal? What isn't an appeal? Because there's lots of confusion about this. Some people think that if you can get an appeal granted, it automatically means either not guilty or the charges are thrown out. And that's oftentimes, most of the times, not the case. So why don't we start with the question, what is an appeal?
Yeah, I think people are really confused about an appeal, right? They think that automatically they get some kind of a right to have a new trial, and that's not the case. What we're looking at with an appeal is some type of an argument that says there was a problem with the trial, right? You didn't get a proper trial for some reason. I think it's also important to point out that appeals are difficult, right? Because you're presumed innocent at the trial level. By the time you're at the appeal, you're guilty. And you are legally guilty by the time you're filing an appeal. So now you got the burden of proof. So almost all the inferences and everything is in favor of keeping that appeal there, right? There's this interest in certainty in the system. So when you're fighting an appeal, you're marching uphill for sure, and you need to know that they are difficult.
Yeah, just by the raw numbers, statistically, very, very low amount of appeals are actually granted. And the idea here is that we want to trust the jury. If you had a jury at your trial, we want to give deference in our laws to the jury verdict. If it was a bench trial, we want to give deference in our laws to the judge who found you guilty. And so the idea here with an appeal is something went legally wrong. Something went legally wrong. And you'll understand soon why I'm emphasizing that, because there are different forms of post-conviction relief we'll talk about in a little bit here, where it might shift the focus of what you're looking at. But with an appeal, with a direct appeal, something went legally wrong during the trial level that deprived you of a right to a fair trial.
Yeah, if you think about it just conceptually, if you got a fair trial and the result is you're guilty, okay, that's the end. There's nothing else to talk about. What you're arguing is there was a problem with the trial. I had usually a legal problem. And, you can raise legal appeals for many different issues, but there are some common things. And I listed some of them here down in my notes. One of the things that's a very common area for appeal, and we've done tons of appeals, is the erroneous admission or non-admission of evidence, right?
Huge ground.
Yeah, so the defendant is actually saying, hey, something was introduced into evidence, usually by the state, right, that shouldn't have been introduced into evidence. And you got to have an objection here, obviously. We'll talk about waiver in a little bit here, too. which is a very big issue on appeal. And this is why, if something is questionable and you're the defense attorney and the prosecutor's trying to get that into evidence, you object. You sometimes object just for the record. If you blow that, you don't object, you're going to have problems down the road. Or the defendant wanted to admit something. Said, Judge, we moved to admit this. We want the jury to see it. Judge says, sorry, not going to admit that piece of evidence. Jury's not going to get to see it. Those are the kinds of issues that are evidentiary issues, and you want to make the case that the judge made a wrong legal decision during the trial. Also, jury instructions. This might be the most fertile area for appeal. I mean, the jury instruction is, in essence, the judge instructing the jury on what the law is. Now, everybody knows, I think, I did this video on jury nullification. I would love for the jury to say, no, we get to judge the law as well. But instead, the way it works is everybody on the jury is sworn to follow those instructions as given to them by the judge. And so there are generally standardized jury instructions, and then there are special jury instructions. At our law firm, we like to draft them up in every case. I think every case I've ever tried, I did my best to write a special jury instruction, right? Because this is a fertile ground for appeal. And defendants are generally entitled to jury instructions on their theory of the defense. If there's an argument that could support that, you're going to ask the judge to instruct that jury on that legal theory, and then you're going to argue about how it's written, right? And later on, if the judge gave an instruction and you were asking for something slightly different, what you're saying to the appellate court is there was a problem with this jury instruction. It should have been worded differently. The judge was instructed incorrectly. Or there was another jury instruction that was maybe a standard that should have been given and the judge refused to give it. There was some problem with the way the jury was instructed on the law.
Yeah, there are many issues with the jury itself that could be fertile grounds for an appeal, not just the jury instructions, but if you guys have been following this series, you remember during the trial video where we spent some time talking about Voir Dire, which is the jury selection. And so a lot of times you might object to a certain juror being appointed to the panel and the judge disagrees with you and thinks that the juror should be allowed to be on the panel. Or perhaps the judge refuses to strike a juror for a cause when you believe that the juror should have been struck for cause, and now you're forced to use one of your preemptory strikes if you have preemptory strikes in your jurisdiction. In other words, you got to use your resources in order to get rid of somebody who should have been struck in the first place. So if you believe that the judge made some mistakes during the actual jury selection, that could also be fertile grounds for appeal.
Yeah, and this is one of the things, Andy, you and I teach the younger lawyers when we're going through trials, right? To take a section of your trial notebook and label it appellate issues or potential appellate issues. And as you're going through these things, right? Because in trial, you're in the heat of the battle. And when you say, hey, judge, I move to strike this juror for cause, and then the judge says, well, what does the state have to say? And the state says, no, I don't think there's a reason to strike this juror for cause. I think he or she could be fair. And it wasn't, just because they said, I hate all defendants. Oh, that's not a reason to think they wouldn't be fair or something like that. Of course, that's an exaggeration. But if the judge says, okay, I'm going to go with the state on that, I'm not going to strike this juror for cause, that's when you get out your pen and you write on day one of the trial, I moved to strike juror number 26, and the judge said no, and then that's just flagging that as a possible appellate issue, assuming things go badly.
Yeah, there's even more fruitful ground regarding jurors, specifically when you're assessing a case for an appeal, and that can be, what if the jury engages in misconduct?
That's right.
What if a juror shows up drunk or high?
That's right.
What if a juror falls asleep during an important part of testimony? These are all things that a good lawyer is watching the courtroom and seeing reactions of the jury constantly to different types of evidence. And once or twice in my career, Mark, my eyes have gone over to the jury box and seen somebody either not paying attention or distracted or looking somewhere else, or, there might be jurisdictions that allows jurors to have access to their phones during trial. They could be checking their phones or staring off into space. These are all things that we take note of as attorneys, and it could be fruitful grounds for an appeal.
Yeah, jurors get an admonition from the judge, and among them are things like, look, don't do separate research on the case, don't conduct any experiments on the case. But not all jurors listen. And sometimes this stuff doesn't come up until after trial. You find out that, back in the jury room, they were doing some kind of research, or somebody said, I went out this weekend when we weren't in in session here, and I looked at the scene, and I found out this, that, and the next thing, and here's what I think, and okay, that stuff is not supposed to come into a trial.
Or even I went home this weekend in the middle on the trial break, and I looked up on the news all the coverage of this case, and I did some research about what the public thinks about this case. That's juror misconduct.
Yeah. Communications with the lawyers, communications with other jurors about the case before deliberations start. All these things come under the category of sort of jury misconduct. These are legal issues that you can raise in your appeal. Also, things like insufficient evidence. You can always make the case that there just wasn't enough evidence to support the verdict. These can be hard arguments, but these are oftentimes subject of appellate briefs. They're issues that are raised by lawyers. Also, there's prosecutorial misconduct, right? Sometimes prosecutors argue things that they shouldn't argue. They vouch, they say their opinion about what's true or not true. They're not supposed to do that. They may withhold evidence, things of that nature. So there are several ways prosecutors can act improperly, and these also can support grounds to appeal.
Yeah, sometimes they can misrepresent the evidence to the jury in not a opinionated, argumentative way like you would see in a closing argument, but just blatantly tell the jury the wrong thing, something that the evidence doesn't show, and that could potentially be grounds for appeal. And of course, as all of these things are happening, a good lawyer is preserving each of these issues with an objection and letting the court know that, hey, there's something going on, Judge, that's problematic, and a good judge will look at these objections very carefully. And not necessarily just out of the goodness of their heart or the love of justice either. The judge doesn't want to be reversed on appeal, and so a good judge will look at these objections very carefully.
Yeah, you can also go after the defense attorney, the trial attorney on the case. There's, you have a constitutional right to effective assistance of counsel. Now, it gets a little tricky here because when you're doing an appeal, you're really just looking at what's on the record. And so in some jurisdictions, you can raise ineffective assistance of counsel if you think that there's enough evidence there in the record to make the case to the judge that, hey, this defense attorney did something that no reasonable defense attorney would do, or failed to do something that any reasonable defense attorney would do. And in addition, that thing actually would have made a difference in the outcome of the case.
Yeah, let's talk about the standard for ineffective assistance of counsel, because really the kicker there is that second prong, right? The first prong is that the lawyer's conduct fell well below the standard of care imposed by the bar of that state or that jurisdiction. But that second element, that you also have to show that it would have made a difference had they done the right thing. And so there's a famous case in our Supreme Court about this where a lawyer actually fell asleep during a death penalty trial, and pretty foreseeably the defendant was convicted and appealed. And the court took a look at the case and said, well, while we do find that falling asleep during a capital case does fall well below the standard of care imposed upon lawyers by the bar, they didn't meet the second prong by showing it would have made a difference. Maybe it wasn't an important witness that he was sleeping through. Maybe all that testimony was going to come in anyway. Maybe he didn't have any cross-examination questions for that particular government witness. Maybe the jury didn't notice him and so weren't prejudiced. The burden is on the defense to make a case that it would have made a difference. And because that particular defendant neglected that second prong, I remember that conviction was affirmed.
Yeah, I remember when that case came out and the way it played in the press. Lawyer falls asleep. And this was, I think, back at the time when the sentencing on death penalty cases was done by the judge. And there was some witness up on the stand and the lawyer was just sleeping. And, of course, it was reported that falling asleep during death penalty trials still isn't enough for ineffective assistance of counsel. And it really sounds crazy. But when you dig into it and you look at it and you say, well, okay, during the time this guy was sleeping, it was sort of a routine testimony and there was nothing that the defense attorney could have done. So while it was below the standard, it didn't make a difference at the end of the day. And you really got to hit both prongs of what we call the Strickland Test. And if you don't hit that second prong, sorry, it's not ineffective assistance counsel, no matter how outrageously below the standard.
Yeah, there's something about that just shocks the conscience. You're
yes.
like, they should do something about it, but that's the Strickland Test, and that's the standard. If you're getting kind of a feeling here that, wow, this is really difficult in a lot of these situations to get an appeal granted, refer to what we said earlier. The rules are in place in order to defer to the judgment of the jury, of the fact finder at trial. And on that note, let's talk about harmless harmless error, which is another hurdle to winning your appeal. What's harmless error, Mark?
Yeah, I mean, the concept here is you don't get a perfect trial, right? There are going to be mistakes that are made by everybody involved, right? If you try a case twice, things happen differently. And so you're not entitled to a perfect trial. You're entitled to one that satisfies due process, which means that there can be mistakes that are made along the way. And just because you point out, hey, here was a mistake, the judge maybe let in a piece of hearsay evidence that shouldn't have been let in, the judge made a wrong evidentiary ruling, but the court then looks at it and says, is this the kind of thing that would have made any difference in the case? And sometimes they say, well, yes, the judge let this piece of evidence come in, but there were 10 other pieces of evidence that went exactly to the same point that came in properly. And so this one mistake, while it's an error, it's a harmless error, and we're not going to give you a reversal or a new trial based on that. And this is any lawyer who does appellate cases, harmless error is your enemy, because it's hard enough to show that there was a mistake, and then you have to argue the second part of that. Hey, this would have made a big difference. We think the jury might have done something differently, or something different would have happened here. And a lot of times the Court of Appeals will say, yeah, it's a mistake, but we just don't find it to be that kind of a mistake. It's not the gravity. The gravity of the mistake is such that it really doesn't make any difference to the outcome. So sorry, it's an error, you're right, but it's harmless error, so no, we're not going to give you any relief.
So every criminal defendant in the United States of America has a constitutional right to an appeal, and that's true whether or not you had a bench trial where a judge was your fact finder, as we've mentioned in the past, maybe for a lower level offense like a misdemeanor trial, or whether you had a felony jury trial and get convicted. Everybody in the United States of America in a criminal trial has the right to an appeal. But there are some ways that you can waive your right to appeal or lose your ability to appeal. We've already talked about one of those, which is if your lawyer's asleep at the switch and doesn't properly preserve the objections when things go wrong in court. So there's another way that you can actually waive your right to appeal, which is probably the most common way that people waive their right to an appeal, and that is if they give it up as part of a plea deal. And this is actually very standard. Most plea deals, in fact, when a defendant enters it, there's a clause in there that says, I agree to this punishment and this term and this punishment and this term. Oh, and one of the terms I agree to is I am waiving my right to change my mind via an appeal. I am accepting this as the sentence, and I understand that I can't appeal this after I sign it. And in the colloquy at the change of plea, the judge is going to make sure that that defendant knows that they are giving up that right to appeal along with those other important constitutional rights.
Yeah, here's where they get you, right? A plea is just a contract, right? It's a contract between the defendant and the prosecutor or the state or the government, depending on the jurisdiction you're in. And you can put anything in that deal, almost anything in that deal that you want. And one of the things that the prosecutor wants is, you're not going to give me aggravation on appeal here. So I'm going to have you, in addition to plead guilty in exchange for whatever it is I'm giving you, I want you to say that right to appeal, absolute right to appeal that you have in any criminal case, you're giving that up. Mm-hmm. And so that's a big part of the plea. Now, we'll come back to this. There are some parts of the appeal you can't waive, right? And courts have said, well, there are some things that we're just not going to let you waive. You may be unaware of things, right? The defense attorney might have said, oh, a guarantee, if you take this deal, you get probation. And you say, okay, fine, I'll waive my appeal, and the judge gives you prison. You got a problem here, right? If you couldn't come back and complain about the bad advice that your lawyer gave you, essentially ineffective assistance of counsel, or prosecutorial misconduct, right? What if they didn't tell you about some important piece of evidence and now they get you to waive your appeal and you're like, hey, I wish I had known about this other witness who had come in and said, no, it was actually me who did the whole thing, or something along those lines. So you can't waive everything.
Yeah, there's some things that we consider so fundamental to due process and justice that the courts have universally said, you can't waive that right.
Yeah, and sometimes you can do this in the state court, and sometimes you can do it in the federal court, where you say, okay, I want a limited waiver of appeal. So this comes up, imagine a context where you feel like you got a really good motion to suppress, right? Say it's a drug case and the drugs are found all in the trunk, and you want to argue that the search that you complained about and you moved to suppress the evidence, the drugs in the trunk, and the judge said, nope, I'm not going to suppress it. And now you take a plea, but you say to the prosecutor, you know what, I still want to appeal that one issue. Prosecutor may agree and say, okay, you waive your right to appeal except for the right to appeal that motion to suppress that you previously brought and lost. You can appeal that issue. So sometimes you can carve out something else that you want to appeal. Prosecutors don't love this, right? Because they still got work that they're going to have to do on appeal. But there have been times in my practice where I've done this on several occasions where I've preserved a limited right to appeal on a specific issue. Sometimes that's a good way to resolve a case because, if you don't want to go to trial and it's just this one issue you want to litigate and otherwise you take the plea, it can be a good way to resolve the case, and a lot of judges will accept that kind of a resolution.
Now, different states have different rules, and so I want to go into a few state-specific things that you cannot waive your right to appeal in terms of by a plea agreement or even a guilty conviction. Here in Arizona, for example, we have a statutorily protected right to an appeal that's actually right baked into our criminal procedure. In Arizona, it's Rule 32 and Rule 33. 32 is for when you are convicted following a trial, and Rule 33 is after your conviction after pleading guilty pursuant to a plea deal. And many states have similar statutorily enshrined rights to what we call post-conviction relief. And this is different than an appeal. We'll say more about it very soon here. But first and foremost, if you live in a jurisdiction where there's some other form of challenging your conviction via the state's statutorily protected post-conviction relief process, you cannot waive that pursuant to even a plea agreement.
Yeah, I think it's also important to note that the state doesn't get to appeal an acquittal, right? That would be protected by double jeopardy. Imagine that you go to trial, you win, jury comes back, says not guilty, you're acquitted, you're cheering up and down, and now the state files an appeal and they say, oh no, we want a new trial for some reason. Sorry. That's one of the very important protections that you have in the Constitution, the federal Constitution, the protection against double jeopardy. You're not going to get twice tried. Think about how that would go, right? Maybe you spent a bunch of money on hiring a criminal defense lawyer, you got a good result, and now they charge you again. They get it reversed, you got to pay again. So sorry, you get acquitted, you're done, that's the end. Government doesn't get to appeal.
Little bit of a snafu here, though, and it's something our listeners have maybe heard us complain about here. We talk about this legal fiction where the state and the federal government are two completely separate, independent entities. And there have been some cases, some high-profile cases in this country that frankly are outrageous, where the person was acquitted on the state level and then the feds charged him for essentially the same crimes and got around this double jeopardy clause by saying, look, we're independent sovereigns. Just because the state court, he didn't get convicted there. We're the feds. We don't answer to them and they're their own thing. We think this is outrageous. And to be fair, it's not used often by prosecutors. Usually the public gets pretty outraged when this happens, especially in high-profile cases. But we've seen it, and legally they are allowed to do it.
Yeah, I think it's pretty outrageous, but yeah, that's true. They can try you twice, once in the state and then once in the federal for essentially the same conduct. Double jeopardy doesn't apply there at all.
Yeah. So just kind of talking about on the state level what the structure is of the appellate courts, because once again, different jurisdictions have different rules. But oftentimes there are the trial level courts. That's where the trial takes place and a conviction occurs. And then after that, there are appellate courts, and states can have multiple appellate courts broken up into different sections of the state. They can have different divisions, Division 1, 2, and 3, and so on, that basically say everybody, all the trial courts in this particular area come to this particular division of the appellate court. And so when you get convicted in that trial level court, you go up one level to the Court of Appeals. And the Court of Appeals is often comprised of multiple judges who will take a look at that appeal. And once again, different rules. Make sure to know your own jurisdiction's rules, but say it might be a panel of 3 judges or 5 judges or something like that. They take a look, they vote, they follow whatever state-specific procedure is there. And they have a few options at that point. They can simply deny your appeal on the pleadings.
Yeah, so a lot of the appellate courts are 3-judge panels, and assuming you haven't waived your right to appeal, that appellate court is going to review your whole case. They're going to look at, you have a constitutional right to appeal at least one level up to that normally called the Court of Appeals. And they will go through the case. They will look at it. Doesn't mean they're going to grant it, but they will definitely look at it. They could grant it and then take some action. They could also deny it, say, sorry, we don't find any legal errors here. You can then appeal to the next level, which is oftentimes called the Supreme Court of the state. But here, you, unlike the lower level, you got no right for the Supreme Court to hear that. Sometimes they're just going to say, sorry, we decline to exercise our jurisdiction here. We're not even going to look at it. Goodbye. Or they will grant cert, as we like to say.
Certiorari.
Yes, and what that means is we've decided in our discretion that you've made an intriguing enough argument for us to take a look at. Doesn't mean they're going to grant it, but that's always a good sign when they decide to exercise their discretion and look at it. So you only get one level up as a matter of right. Beyond that, you can petition the higher court to look at your case. They may look at it. They may not look at it.
Yes, they're very picky in the Supreme Courts about which cases they want to hear. Usually it has to do with an interesting point of law or a new novel piece of law that the courts are confused about, and there's conflicting rulings about how to interpret this particular statute. Those are the ones that the Supreme Court's kind of trolling the state for. They want to use the opportunity to smooth out in a public forum exactly how we are going to be interpreting this particular statute in our state.
Yeah, and so generally speaking, if you got a state criminal conviction and you haven't waived your right to appeal, you got to take that through the state appellate courts first. But if you've got a federal issue, and there are federal issues out there in every state case, right? Fourth Amendment issues, right for effective assistance of counsel is also a federal issue. There are other federal issues out there. And assuming you have argued these up through the state system and said, hey, we got a federal issue here. You have federalized You have federalized that appellate issue. You can then take that, even if the state Supreme Court says we're not going to hear it, or they did hear it and denied it, and now try to pitch it to the federal court. So that's called a habeas action in the federal side. You don't get to bring those state issues over to the federal side because the federal court's going to say, sorry, we don't decide state issues. The state Supreme Court is the final word on state issues. But you've raised this federal issue here, right? The Sixth Amendment, ineffective assistance of counsel issue, the Fourth Amendment, right to be free from unreasonable searches and seizures, or some other federal issue. And we're happy to look at that. Now, there are time limits on all of this, right? So even on the very first notice of appeal, if you're going to appeal a criminal conviction, you don't get to sit around. Jurisdictions often have very tight time limits. You could have 10 days, 15 days, 20 days, 30 days in different places to file that notice of appeal. You want to take this over to the federal court, they're going to look at it and say, look, you had to have diligently pursued that appeal in the state court. If you just sat around, usually it's a 1-year time limit other than the time that you spent litigating the issue in the state court. Yeah. If you've blown that time limit, federal court's going to be closed to you. So you got to really be careful if you have lost at a trial, whether it's a bench trial or a jury trial, and now you want to appeal, you got to be diligently pursuing your rights on appeal or you're timed out. And that's one way a lot of people miss their right to appeal because they just simply didn't act in a timely manner.
Yeah, a couple of really important things to note here about filing a habeas is that a good attorney is always arguing both the state constitution and the federal constitution. And I see attorneys screw this up a lot. When you're going through a state case, some attorneys have the inclination to only focus on the state statutory law, the state constitution, everything like that. In every motion that we file at our law firm, we're talking about the federal and the state constitution. And the reason is we're trying to be as diligent as possible to preserve everything, right? The idea is that we want to win the case, but we want to make sure that our client has a bigger parachute if it doesn't go the way that we want it to go. And so for that reason, we make sure to not only preserve all the state issues as they come, but we're federalizing every single issue to the extent that we can, knowing that if the state courts let our client down in the appellate process, there's still the feds to come and look at it. And the rationale here is that the feds are the final answer here, that they're kind of supposed to be keeping an eye on all the states. All the states can make our own wacky rules. We can have our own criminal procedure. We can enshrine certain rights. But the idea is that the feds are there to keep an eye on the states to make sure that they are at least meeting the benchmark of the United States Constitution and the rights enshrined therein.
Yeah, and of course, the way you fight these things and raise these things are in what we call the appellate briefs, right? And so the defendant who is appealing becomes the appellant, and they file an appellate brief. You may or may not get oral argument. If the Court of Appeals says, we're interested in this, we got questions, they will then set an oral argument, and both sides will come into court and get to sort of argue about the issues. But it's not just the issues. You're also arguing about something called the standard of review. People may be familiar with this if they watch football, right? Imagine there's a play on the field and the coach throws the red flag, and you hear the announcers say, okay, the referee is going to look at this thing and decide now. The official is going to determine if there is, and I forget exactly the standard, but I think it has to be irrefutable evidence, right, that the call was wrong. That's the standard. Well, we have standards as well. They get this, of course, from the court system. And so if you're talking about a legal question, if you're saying in the briefs that you're arguing to the appellate court, it's a legal issue. It's purely a legal issue. The judge just got it wrong. The Court of Appeals is going to say, what's the standard of review? And you're going to say, de novo. What that means is look at it with fresh eyes. You guys are just as prepared to answer the question that's a purely legal question as the trial judge was. So you look at it with fresh eyes. We call that the de novo standard. You like that standard if you're the appellant because you're just starting from scratch again with the Court of Appeals and just saying the trial judge just simply got it wrong. Then there are factual questions, right? And so if the judge got it wrong, you got to show it's clearly erroneous. This is more like the NFL standard, right? You got to show that the call on a factual question was clearly wrong. There's not a question or arguably wrong, or there's maybe by preponderance. It's got to be clearly wrong.
It's a high standard.
We call that the clearly erroneous standard, and you don't like that standard if you're the appellant because that's a tough standard to show. This one is closer to the NFL standard, right? You got to have clear evidence that the call was wrong. That's what we apply to factual disputes on appeal. Then there's discretionary questions. Well, the judge had the discretion to do this or that. The standard here is going to be something called abuse of discretion. So the Court of Appeals might say, well, no, we might have done something different. We think most judges might have exercised their discretion in a different way, but it's not an abuse of the discretion standard. This is a tough standard, right? This is maybe one of your hardest standards to show. And there are others. We're just giving you sort of a general overview here. But if you're fighting an abuse of discretion standard, you really got to show very clearly that the judge was sort of out to lunch, was out in left field on this call.
So clearly erroneous standard, abuse of discretion standard, very, very high bars here. And our listeners are probably starting to see a recurring trend here, which is that the standards are in place in order to skew leaving the verdict in place, leaving the trial court's decisions in place, leaving the judge's decisions in place. We give a lot of discretion and a lot of deference to the decisions that were made by everybody involved at the lower level. So that's why these standards are set
just
so
like
high.
the NFL, right?
Yeah.
The ref on the field who made that call right there, that call's going to stand unless there's really clear evidence to the contrary.
Yeah, a couple of extra things here that people should know. An appeal is limited to the actual record at trial. And so what does that mean? That pretty much means the trial transcripts of the things that were recorded that were said at trial, exhibits that were entered as evidence are considered, minute entries, of course, any motions that were filed and responses and replies. All of the filings are included in the record. But things it doesn't include is private conversations you had with your attorney or things that ultimately were not admitted. And so, yeah, it's really important to know that there's a limitation when you're in the appellate world to the things that were actually put onto the record at trial.
Yeah, the Court of Appeals isn't taking new evidence. You're not putting people on the stand and having witnesses and this and that. The appellate record is really what's at issue here. So you've got to, in your brief, cite to on day 2 of the trial, on page so-and-so, paragraph such and such, line so-and-so to so-and-so, here's what was said. This isn't something you're going to get to present new evidence. At the end of the day, that's really the difference between the post-conviction relief, right? Because there are some appellate questions, like imagine the situation situation that we raised earlier. The lawyer says, look, to the client, look, just go in and take this deal. The judge is going to give you probation, guaranteed, trust me on this. And the client says, okay, I'll trust you on this. And I go in and the client goes in and takes the deal and gets prison. There's nothing in the record that the lawyer made this promise. So this is not an ineffective assistance of counsel claim that you're going to be able to raise on a direct appeal.
Yeah.
This is the kind of thing you need evidence, right? You need to put that lawyer on the stand and say, Mr. Lawyer under oath, did you tell your client before he entered the plea he was going to get probation? And then that person says yes or no, and now that becomes part of the record. So you have to create a new record. And so there are some issues that
even more commonly, introducing email correspondence between the defendant and the lawyer to show ineffective assistance of counsel. Witnesses, I was there, says the family member or friend, when the lawyer promised him that he'd definitely get probation for this. So your point's a very good one, which is you need some extra things outside of the record to establish it.
That's why these types of actions, these post-conviction ones, they don't go to the appellate court. They go back to the trial judge. So the trial judge, who's used to putting people on the stand and taking evidence and creating a new record, you give them an opportunity for the first time to rule on something. And then if you don't like the issue there, now you go to the appellate court from there.
Yeah, so this is back in the world that we mentioned earlier, which is statutorily protected ways that you can challenge your conviction outside of an appeal. And this would be what's oftentimes called post-conviction relief. Not all states have this, and states have different versions of it. Sometimes you have to ask permission from your state, the state's appellate court, to file it. So there are some interesting state-specific nuances. But as you mentioned, it opens up a whole new round of different challenges. For example, here's some common things you might bring up in a post-conviction relief petition. Ineffective assistance of counsel is by far number one, right? This is where you're arguing the conduct of my lawyer fell below the standard of care required, and it made a negative difference in my case, whether it was he didn't present the right defense, or he misinformed me about the plea, or he gave me some bad legal advice, or he just didn't rise to the standard in terms of his decisions strategically. We've seen a lot of these too, where, for example, in a case where it's really obvious to any reasonable lawyer that a certain type of expert should have been hired, yet the lawyer neglected to do that for no good reason.
Yeah, these are things outside the record, and that's really what the post-conviction relief is for. Other things out there as well, say, the law's changed since you've been convicted. There's newly discovered evidence. Something has now come up that couldn't have been found through the exercise of reasonable diligence. In other words, you did everything you could, and there's no way you could have found this evidence, but now something new has surfaced. This is normally the kind of vehicle that you would want to now come back into court. This is popular with evidence that couldn't have been tested by DNA maybe decades ago, that now all of a sudden we can test with DNA. These are the mechanisms that you use to now reopen the case.
Absolutely.
So every appellate lawyer knows your enemy in an appeal is waiver. Mm-hmm. And the idea here is just like we were talking about before when we open the record and it goes back to the trial court, you have to give the trial judge an opportunity to fix the problem before it goes to the appellate court. So if during the trial a prosecutor tries to introduce some evidence and the defense attorney doesn't object, then later on appeal, if you complain about this, Court of Appeals is very likely to say, sorry, this is waived. And the reason it's waived is because the defense attorney failed to give the trial judge an opportunity to fix that mistake at the time. So waiver is one of those things that really kills a lot of appellate arguments.
And just because that happens doesn't necessarily mean that that defendant is SOL, right? Because there could be something outside of the appeal, a forum to complain about it in the state's laws, and that's the type of thing we see in that post-conviction relief, right?
Yeah,
if they don't
if you can bring it new. But if you failed to complain about it during the trial, oftentimes the Court of Appeals is going to say, sorry, you waived the issue, we're not going to consider it. Now, there are some times where an attorney will fail to object, and the prosecutor will say, well, this issue was waived. And the Court of Appeals will say, yeah, not so fast. This was such a fundamental issue, such a major problem that it goes to the fundamental fairness of the case. And even though the defense attorney didn't object, this is going to be such a basic issue that we're going to still look at it.
That's right. You're always on the lookout for case law about fundamental error, especially if the lawyer was kind of asleep at the switch during the trial. Because if you can argue that, if you can argue, look, this issue is close enough to a Supreme Court case where they said that this particular issue cannot be waived. It's so important to fundamental fairness of getting a fair trial, of due process, that even if the lawyer was completely ineffective, the defendant in a free country still has to benefit from this particular thing. So, yeah, you're always on the lookout for things that you can raise as a potential fundamental error.
Yeah, and then at the end of the day, the Court of Appeals is going to say, look, we either disagree with everything that was raised, we affirm the conviction, and that's the end, sorry. We're going to remand it back for maybe a new sentencing, because remember, you can appeal not just the judgment of guilt, but also the sentencing. And so sometimes the appeal is, okay, maybe there was no problem with the trial, but the judge did something wrong at sentencing, and the Court of Appeals will agree and say, okay, we're not reversing the trial, but we're going to remand it for a new sentencing, and we're directing the judge to consider this or not to consider that. Or they just say, sorry, it's reversed for a new trial.
Yeah, on the remand, a couple of things that might be an example of something you would challenge is perhaps the prosecutor threw an enhancement on the charge that the judge shouldn't have allowed. And prosecutors have these enhancements that they like to play around with and try to stick on cases to boost up the prison time and the penalties. But there's some guidance from the legislature on those, on when they apply to certain types of cases. And the judge may allow an enhancement that you complain about later. So that's a fruitful one. And then also, sometimes judges will calculate the time incorrectly. Yeah. As simple as that. There's certain scales of time and ranges of time that judges are allowed to give depending on how many priors and depending on what enhancements are done. And sometimes judges just screw that up. They do an incorrect calculation, or the probation department gave the judge a recommendation that was outside of what they were legally allowed to do, and the judge just defers to the probation department. So yeah, as you say, even if everything went correctly at the trial, oftentimes there are still things you can bring up with the sentence.
Yeah, sometimes those enhancements a judge will allow and do a sentencing, and then the Court of Appeals will say, sorry, that enhancement had to go to the jury, and the jury had to decide this, so now we're going to remand for sentencing without the enhancement. Look, this is a 30,000-foot overview of appeals and post-conviction relief. There's really a lot more to talk about here. I think what's important, if you're headed for trial, make sure your lawyer is preserving issues that could be mistakes so you don't suffer from that waiver argument, and is keeping a record of every. In fact, if you're a defendant going to trial, you might want to take a list of every time your attorney objected to something and the judge overruled that objection. Those are all the kinds of things that an appellate lawyer would look at. And, you always want to be prepared just in case that jury does something you don't want that jury to do.
And make sure your lawyer is raising both the protections that you're afforded by the state constitution and the federal constitution. You benefit from both, folks. You don't want your attorney only raising issues that are relevant to one or the other. So all important words of the wise for an attorney in these types of situations.
I think we've come to the end, brother.
Oh, man. What a great series this has been, and it's been so much fun making it with you, Mark. As you pointed out earlier, we could spend all day talking about this. Every single video in this series, we could have spent all day on each one of them. But once again, the goal of this series was to give the 30,000-foot view, quick and dirty, segmented into something that makes sense in terms of the chronological flow of a trial in the criminal justice system. And I feel like we accomplished it pretty well, my friend.
While it may be the end of this series, it's not the end of us fighting the state.
Yes.
We just like fighting the state too much. There'll be other fights.
No doubt. All right. Well, thank you to everyone who tuned in for the series. And if we brought up something that piqued your interest from a previous episode, feel free to skip back. We've got a playlist for the entire series in the description of the video. Make sure to go and check out attorneysonretainer.us to learn all about our self-defense program and what it can do for you. If you want to learn more about our law firm and how we defend people in the justice system, be sure to check out attorneysforfreedom.com. As always, if you liked this video, leave us a like down below, shoot us a comment. Definitely share it with a friend if you enjoyed it, and subscribe to the channel. Until next time, this has been attorneys Andy Marcantel and Marc J. Victor signing out.
Peace.